There's actually something else that needs to be mentioned. I thought I mentioned pretty much everything. I haven't actually finished looking through the whole House of Lords standing orders, all of them, but I think they'll probably be similar. The other situation is this, right? If you look at, the Petitions Committee, right, they're all members of the House of Commons. If you look at the Procedure Committee, they're all members of the House of Commons, right? But when they do, a report, something like a review of privilege, for example, like a first report of a committee for, 1997 or whatever, working on that report, you've got members of the Commons and members of the Lords, right? But that's actually, I'm pretty sure that is actually something different to the normal committees of the House of Commons. I'm pretty sure that according to Standing Order number 87, that it means all committees. It means generally, your whatever, just pick a handful of committees in and around the work of Commons. I think that it means the Attorney General is meant to be able to attend because, for example, the Privileges Committee of the House of Commons is made up of members of the House of Commons, right? As is the Petitions Committee. That is when you might need the Attorney General to attend deliberations, right? Massively for the House of Commons. But he can't vote or move, but he can attend and deliberate and give information, right? So, basically, we'll call it consultation, right? So, if it's for the House of Commons privileges, which are separate from the House of Lords, which is you wouldn't have a member of the House of Lords deliberating in the House of Commons privileges because they're meant to be, they're judges of their own privilege, right? Now, there is something in the House of Lords when they make an order or judgment, right? But it's an official order or judgment and pass it to the House of Commons. I think they've got to comply or obey with it when it's a judicial decision, because when you used to impeach someone, you see, the Commons would vote on it as a body. And then I think once they'd made their verdict or decision, then I think it was passed to the House of Lords, right? And then that's when you have the Attorney General making a representation. And then the Lords are like the judges. If they make an order and then pass it back to the Commons, they've got to comply with the order as if it's a judicial order, but only because the Commons as a house voted on it and then passed it over to the other house, right? If you see what I mean. So having Baron Hermer as a member of the House of Lords as an individual and then taking part in deliberations for example, on the Privileges Committee in the House of Commons, where it's only meant to be members of the House of Commons, and 87 Standing Order says that, being a member of that House, he can attend, it would be odd. Now, Starmer's a lawyer himself, but even he's not on the Privileges Committee, right? He doesn't say the Prime Minister can attend or a Minister, right? So, for that particular reason, and actually that is the earlier reason that I came up with, that was one of the first issues before I found the House of Lords information, and I actually think that because obviously there's different rules for committees and standing committees, etc., but I'm quite certain that if you read it, I think it does mean that they're allowed to have what it means is that committees of the House of Commons, which are constituted out of only members of the House of Commons, have got the right to have the Attorney General there. In fact, they might need him, right? And if he's a member of the House of Lords, then he doesn't have a right to participate. Therefore, they're short of someone to advise them. Whereas the House of Lords have got the Law Lords to advise them, right, on law if they need it, which is kind of different when it comes to law, legislation and bills and processes of the House. But when in the House of Lords, when the Attorney General can sit in the woolsack, but he's not a member of that House, but he's a member of the House of Commons, but he can, he's an assistant, right? That's different because it's to do. It's not. I don't think it's necessarily for bills being put through. I think that it's meant to be to an assistant for legal proceedings. Maybe he can. Now if he can deliberate, or be the attorney. But this is the thing: they had a separate thing for that, for committees and looking at legislation and law. Firstly, the whole House votes on it anyway, right? And it's said that the Lords deliberate for bills being put through, like, the law Lords. So I think that my model on it and my interpretation is the right one. I think it's the correct one. And I think that the history itself is the judge of it, right? They just didn't do it. They just did not do it if you check properly. So why Tony Blair did it, and he didn't do it with his first Attorney General, he only did it with his second one, and then Gordon Brown then copied him, but none of the Conservatives did this, and then now it's Keir Starmer has done it again. So it's only 4 times, and it's only since Tony Blair. So, I mean, it just, there's something that does not add up to it. There's something that does not make sense with it. It doesn't seem right to me, because, and actually, I think the main issue is probably the Privileges Committee of the House of Commons, because the Privileges Committee of the House of Commons only has members of the House of Commons as members, right? Unless it's like those end of committee report things, right? Which has both houses. But that's like a report from Parliament itself. It's a parliamentary report, right? Why would you not want to have the Attorney General of England be able to attend Privileges Committee meetings of the House of Commons? It seems odd that because he can't if he's not a member, right? If you want to interpret Standing Order 87, like, he might possibly be, if it doesn't mean that it has to be a member of the Commons, but being a member of the Commons only he can attend the meetings, then it seems to me a bit silly why you would say, okay, we'll have him as a member of the House of Lords, but we just won't bother having an Attorney General to help us out in committee meetings. And, why would the House of Commons, with their own distinct privilege, why would they want, a member of the other house to, get involved in their own privileges? It's traditional for each separate house to be the judge of its own privilege. And even when the House of Commons did impeachments, right, they vote on it as a body, as a single body in house, and then it is passed over to the other house, right? And that's it. And then, I think the Attorney General can make a representation. He might be able to defend the member of the Commons, but obviously the Lords are the judges, right? Because they're hearing it in like a court. It's like a court, right? So, like, the House of... If it was like, Mike Amesbury being impeached in the House of Lords, right? The Attorney General can be his counsel because, like, Mike Amesbury wasn't a commoner at the time. It's, before the Lords, right? That I think that is the correct interpretation of it. I don't. It just, it's logical, it's intelligent, and it's intuitive, and it seems appropriate to what it is, right? And it doesn't seem. It seems quite ridiculous what Tony Blair did and Gordon Brown, and then Keir Starmer as well.